Good evening and welcome to Courts Today by Livelaw. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. The Apex Court today concluded hearing in the electoral bonds case. As you know, that a 5-judge bench comprising CJI Chandrachud and Justices Sanjeev Khanna, B.R. Gawai, J.B. Pardewala and Manoj Mishra was hearing a batch of petitions challenging the electoral bonds scheme. Today was the third day of hearing. According to the petitioners, the anonymity attached to the electoral bonds affects transparency in political fundings and infringes the voters' right to information. They also contended that the scheme allowed contributions to be made through shell companies. The union government, on the other hand, defended the scheme as a method to ensure that white money is used for political fundings through proper banking channels. The government further contended that it was necessary to keep the identity of donors confidential so that they would not face any retribution from political parties. Also, during the hearing, the bench posed several pertinent queries to the central government about the scheme, flagging its selective anonymity and also asked whether it was legalizing kickbacks for parties. The bench observed that it was possible for the ruling party to know the identity of the donors, whereas the opposition parties could not get access to such information. Today, the bench also expressed displeasure with the ECI for not having the data of electoral bonds donation till date. The bench pointed out that as per the interim order passed in April 2019, ECI was obliged to maintain the data of electoral bond fundings till date. The Council for ECI handed over to the court the sealed cover containing data furnished by the political parties in terms of the April 2019 order and agreed to collate the data till the present date. After hearing the parties, the bench today reserved the judgment in the matter. For detailed information on the case, you can visit livelaw.in. As you know, the Supreme Court recently pronounced the much-anticipated judgment in the same-sex marriage case. As per the verdict, the court refused to grant right to marry to queer couples. However, 4 out of the 5 judges agreed to direct the Union of India to constitute a committee to examine rights and entitlements of persons in queer couples without legal recognition of their relationship as a marriage. Well, now a review petition has been filed in the Supreme Court challenging the judgment. The review petition faults the judgment for not affording any legal protection to queer couples despite acknowledging the discrimination faced by them, which according to them amounts to abdication of the court's duty to uphold and protect fundamental rights. It has also been argued that judgment suffers from errors apparent on the face of the record and is self-contradictory and manifestly unjust. The court recognizes the petitioner's fundamental rights are being violated by the state through discrimination, but fails to take the logical next step of prohibiting this discrimination. You can visit our website at livelaw.in to read in detail about the main grounds urged in the review petition. The government of Kerala has approached the Supreme Court stating that the governor of Kerala, Arif Muhammad Khan, is delaying the consideration of bills that the State Assembly has passed. The state government has contended that the governor has failed in his constitutional duties by causing unreasonable delay in considering over 8 pending bills. That 3 bills have been pending with the governor for more than 2 years and 3 other bills have been pending for over a year. The writ seeks a declaration from the Apex Court that the governor is bound to dispose of every bill presented to him within a reasonable time and without any delay. The writ also seeks a specific declaration that the governor has failed in the exercise of his constitutional powers and duties by delaying the consideration of the pending bills on time. If you remember, earlier this week, the Tamil Nadu government had moved a similar petition before the Supreme Court, alleging that the governor of the state had positioned himself as a political rival to the state government by excessively delaying consideration of bills that the Assembly had passed. The Supreme Court is going to examine whether a transgender woman who has undergone sex reassignment surgery can be an aggrieved person under the Domestic Violence Act or not. and whether she has the right to seek interim maintenance in a domestic violence case. A bench of Justice Vikram Nath and Justice Rajesh Bindal has granted leave in an appeal filed against the Bombay High Court ruling that had held that a transgender person who has undergone surgery to change gender to female can file a complaint under the Domestic Violence Act. This was in a case where the High Court had dismissed a man's petition challenging maintenance awarded to his wife, who is a trans woman. The High Court had held that the word woman under Domestic Violence Act is no more limited to the binary of women and men and includes the transgender person also who has changed her sex in tune with her gender characteristics. The appellant has now moved the Supreme Court and has contended that there is no certificate issued to the wife for changing the gender identity to a woman, and hence she cannot be treated as a woman under the provisions of the Domestic Violence Act. It has also been argued in the appeal that the provisions of the Domestic Violence Act are gender specific and the legislature has not till date expanded the scope of the legislation. In another update, the Supreme Court has significantly observed that an offender who takes undue advantage of a situation is not entitled to the benefit of Exception 4 to Section 300 of IPC. In this case, the deceased wife had poured kerosene on herself to prevent further torture after a quarrel with her husband, who is the appellant. The husband allegedly lit a matchstick and threw it upon her with an intention to kill her. The deceased died due to burn injuries after being set ablaze. The husband was convicted for murder and cruelty under Section 498A of IPC and approached the Apex Court challenging his conviction. He relied on Exception 4, contending that the incident happened in a sudden fight or quarrel. So Exception 4 to Section 300 states that if a person causes death in a sudden fight in the heat of passion upon a sudden quarrel, then it may not be considered murder. Instead, it might be considered a lesser offense, such as culpable homicide not amounting to murder. The question before the court was whether this was a premeditated kill or was it due to grave and sudden provocation, which would not amount to murder. The court ruled out the possibility of this being a case of sudden provocation since they had a history of quarreling. Further, the court said that for application of Exception 4, culpable homicide must be committed without any premeditated mind and without taking any undue advantage. But here, the husband had taken undue advantage of the situation to throw a matchstick at his wife to burn her while she was drenched in kerosene. Thus, the court dismissed the appeal and held the husband guilty of culpable homicide amounting to murder. The Delhi High Court today issued notice on a public interest litigation seeking inclusion of Ayurveda, yoga and naturopathy in Union Government's public health insurance scheme, Ayushman Bharat Pradhan Mantri Jan Arogya Yojana, that is PMJAY. The PIL states that the central government scheme is limited to allopathic hospitals and dispensaries, while India boasts various indigenous medical systems, including Ayurveda, Unani and homeopathy, etc., which are rooted in India's rich traditions and are highly effective in addressing the healthcare needs of the present time. Unfortunately, due to various policies created by foreign rulers, our cultural, intellectual knowledge and scientific heritage has been systematically eroded. It is duty of the state to re-establish the country's powerful civilization. However, the Indian healthcare system is not covered under the Ayushman scheme. It further states that according to the fundamental spirit of the Constitution, Indian citizens have the right to health and they also have the right to choose their preferred treatment and doctor. Therefore, it is government's responsibility to take steps in this direction. A division bench of Chief Justice Satish Chandra Sharma and Justice Tushar Rao Gadela has sought response of the Union Ministries of Ayush, Finance, Health and Family Welfare and Home Affairs as well as the Delhi government. The court has granted 8 weeks' time to the authorities for filing response and has listed the matter for hearing on 29th January. The next update is from the Jharkhand High Court. While expressing strong reservations over a POCSO court's hastily 7 days trial, The High Court asserted that in cases where a statute prescribes death penalty as a possible punishment, the court is obliged to postpone any further proceedings related to the sentencing after clearly informing the accused of their right to present evidence regarding mitigating circumstances. The Division Bench of Justice Shri Chandrasekhar and Anubha Rawat Chaudhary was hearing a death reference for confirmation of a sentence of death awarded to 3 individuals, namely Mithu Rai, Ashok Rai and Pankaj Mohali. The trio was accused of kidnapping a 6-year-old girl, committing rape upon her and murdering her. Upon receiving DNA reports, the investigating officer filed a charge sheet and the trial judge, after considering the evidence, convicted them on 6 counts, including abduction, sexual assault, murder, and concealing evidence. Further, the trial judge pronounced a 72-page judgment of conviction within 7 working days since taking cognizance of the offence. The High Court has highlighted that the trial judge had hastily conducted the proceedings. It observed that the prosecution's witnesses, including those associates of the victim, were examined, cross-examined and discharged within a single day. That the accused were unable to afford legal representation and consequently were assigned a legal aid lawyer. But the arrangement seemed more like a formality, as the legal aid counsel was given no time to prepare the case. The court also highlighted the statutory obligation imposed on the criminal code by Section 235 of CRPC. According to this provision, the court must give the accused an opportunity to be heard regarding the sentence after delivering a judgment of conviction. Accordingly, the court held that the trial was vitiated and the judgment of conviction and order of sentence both were set aside. The court restored the POCSO Act case to its original records. Advocate on record Shobha Gupta has made a representation to the Registrar General of Rajasthan High Court at Jaipur bench demanding rectification of faults in virtual court access. Due to the glitch, she was unable to appear in a case in which she was engaged as the arguing counsel. Saying that missing a posting date can turn out to be detrimental in many cases, the counsel informed that the glitch had happened twice with her. She claimed while she tried to appear virtually in a case, she was kept in the lobby indefinitely without being able to enter the video conferencing. All she could see was a message on the screen that said, "You can join the meeting after the host admits you." However, as per the court master, the counsel was not found in the lobby at the relevant time and hence the matter was adjourned. On the other hand, the counsel asserts that she was still waiting in the lobby. In her complaint, she has cited the Apex Court decision where it directed that all high courts must ensure that no member of the bar is denied access to video conferencing facilities or hearing through the hybrid facility. She said virtual access does not merely mean permission or access in one's own case, but to the entire court proceedings. The counsel has therefore urged to immediately resolve any technical glitches or upgrade the virtual court system. A public interest litigation has been moved in the Delhi High Court seeking removal of allegedly wrong historical facts related to construction of Taj Mahal by Shah Jahan from the history books in schools and colleges. The plea has been moved by the president of NGO Hindu Sena. It is his case that there is no historical evidence of demolition of the palace of Raja Man Singh and fresh construction of Taj Mahal on the same site. The respondents in the PIL are the central government, Archaeological Survey of India, National Archives of India, as well as the state of Uttar Pradesh. It has been averred that ASI has given wrong information on its website that it took approximately 17 years to complete construction of the Taj Mahal in 1648. He has claimed that the tomb of Mumtaz Mahal was nearly completed by the year 1638. The PIL seeks a direction on ASI to carry out an investigation about the age of Taj Mahal, including existence of palace of Raja Man Singh, and to file a report before the court. A division bench of Chief Justice Satish Chandra Sharma and Justice Tushar Rao Gadela is likely to hear the matter tomorrow. Stay tuned with us. I hope you found this video informative and enjoyable. If you did, please consider giving it a thumbs up and sharing it with your friends. Don't forget to subscribe and hit that notification bell so you won't miss any of our future content. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just 89 rupees per month.